You can't eat it all at once. Maybe we should just pick one section, one thing that's a pain point, and work on that. If we try to eat the whole cake at the same time, we will get a stomachache. Okay? Let's just pick one small piece and put all our effort and energy behind that and get that working, let that be a showpiece, and then move forward and let that expand to the next. Thank you.
Good afternoon. My name is Niharika Dhal and I work in the field of construction arbitration. I want to add only one recommendation, that's training for lawyers. There should be some form of formalized training for lawyers because we need to break away from the cumbersome procedural rules of the civil code and evolve with international practice. This training should be a continuous process and it should be accessible. This will, I think, have a significant impact on cost, the time period of an arbitration, and the possibility of settlement in an arbitration. Thank you.
One. Okay, hi, my name is Joginder Yadav. I'm with Cisco India. I won't belabor any of the points made previously. I think a couple of points. One is, when I was working with one of my previous employers, we used to be, afraid of this clause called arbitrary arbitration. We had coined the term arbitrary arbitration, which essentially meant that your client will, your client's MD or CMD would be the sole arbitrator. So that's gone now. It was there under the 1940 Act, and that was it was totally contrary to any principle of justice. I think in the current scenario, being from a technology background, what I would say, and echoing Salman's point, is that technical expertise is required. And I think we need to set up an ecosystem where the marketplace really, we make the marketplace conducive to development of not just technical expertise, whether it's in the technology sector or finance sector or whatever. You need technical experts in every field. With judges being generalists, by far don't get a chance to develop. The other point I'll make is in terms of institutional arbitration, right? We all heard that LCI is going back, or at least shutting the India office. I think that's not conducive, and that's contrary to creating a marketplace, as I said, or market conditions conducive to institutional arbitration, because ad hoc arbitration is not really going to serve anyone's interests other than a few self-serving. And even if it's not self-serving for people involved, I think it's not an efficient mechanism to resolve disputes through arbitration. Thank you.
Mr. Chairman and fellow delegate, I'm O.P. Gupta. I'm a former chief engineer, and at the moment I'm acting registrar, Construction Industry Arbitration Council. My views are that we should adopt the institutional arbitration. There are disputes about the ad hoc arbitration and the institutional arbitration. The people on the verge with their state that the ad hoc arbitration is most important. They have some methods. Once the administration fee is higher, which is not correct. Ultimately, we see the fee is fixed by the institution, and it is low for the claim if the claim is low, and higher if the claim and counterclaim is higher side. And second, they say there is a bureaucracy within the institution which cause delay, which is also wrong, because the rules are laid down and it can be only changed with the approval of the institution itself. It cannot be changed by the arbitrator or anybody else. The third point, they say the time which is fixed up by the institution is unrealistic. This is also wrong, because the time is decided with the reference to the cost and the claims, etc. And the award which are made by the arbitrator. In the case of the arbitration, in the Construction Industry Arbitration Council, we have laid down that
thank you very much.
I am saying all the arbitrator award will be scrutinized, not for that purpose, only reviewed only. And I say the appointment of the arbitrator is also very important, because what is the thousands of crores of rupees are held up in the construction industry, whereas the arbitrators which are appointed, they are either the retired judges or non-technical, which take more time. And there is a need that the technocrats as well as the advocates who are conversant with that. We are also would have needs that there should be a training to the advocate as well as to the engineer of the part of the legal side and of that, so that they may do it. And secondly, interference of the court is still going on. It should be stopped, and there should be some...
We are running on a very tight schedule, and fortunately we are
now,
efficiently...
in the last I say, the international arbitration hub, it can be there within India also, because we are competent to take all the situations. Our arbitrator are competent, everybody is competent. There is a need to push it. Otherwise, if more details you can refer...
Thank you now, finally.
Hi everyone, my name is Saloni. I am a partner with Kocher & Company. I head the dispute resolution practice. While Mr. O.P. Gupta introduced himself on a lighter note, he didn't mention that he's also postgraduate in Vastu Shastra and Feng Shui. And since we have the pleasure of having him in the room, we should probably ask whether the Vastu Shastra and Feng Shui of India becoming the hub for arbitration is right at this point or not. But, sorry? Yeah, so I don't have much to add from what's been said around the room. We all feel the frustration. We've all been in arbitrations which have left our clients frustrated and at the mercy of the Arbitration Act. It was at 96. Now, I have only two things to say, apart from what I've put together as a note with Mr. Ramaswamy has, and we can circulate in terms of what we need to do to improve the existing ADR system, and a few other points I've put across as to what are the lacunas that I saw in the new Arbitration Act. The only two things I want all of us to consider, and before that, now what? We've all heard this is wrong with the system, remove the judges, the act is wrong, etc., etc. We're not in this room to discuss that. I think we've all have been in plenty conferences and situations to know what's wrong. We know what's wrong. Now we need to act on it. And so, like you rightly pointed out, we need to, in this room, at the end of 2 hours of this discussion, have something concrete that we can go back with and start working on so that the next time we meet, there is a step forward in what needs to be done or what we've done with this discussion. So the only two things I want all of us to consider, and I'm throwing it as a question to everybody, a proper start. We have a new act now. We're not talking pre-act, we're talking post-act. We need to do an in-depth, proper analysis of practical applicability of the changes that have been made under this act, especially the procedural ones. When it comes to practicality, they're not executable. A lot of them leave a lot of room for litigation. In fact, to me, I'm very skeptical about it. It makes it far, far more prone to litigation than it was earlier. But without going into that, the other thing we need to do, apart from studying this act in depth for practical reasons, is that we want one institution. And who's going to take that responsibility? If it's going to be INBA, then let it be INBA, and let it form those practical procedures, etc., like SEAC, like LCIA, where we can get the procedures out of the act, if need be, and act in that manner. On that note, when we get to Pranav, who's with SEAC, Pranav, I'd like you to throw some idea as to how it works with SEAC and, how we can have an independent body in India similar to SEAC. Thank you.
Thank you very much, Saloni. I'm very happy to announce today, in answer to your point raised by you, it's a very, very valid point. We discuss, we found a problem, then what? Nothing. So it's a really big problem in India, particularly. So we accept your suggestion, and we would work out on it on a solution. Besides this, INBA is negotiating with the leading arbitration center from the globe to open a institutional arbitration in India. We have compared the rules of the Singapore, London, and another week came across very interesting arbitration concept, which can deal with the 1 lakh rupees dispute, can deal with the thousands crore dispute in a very, very cost-effective manner. So that's an organization called a COA, that is a Court of Innovative Arbitration. It's a German-based organization and in Munich. So we will be sharing the details as the question and session we are receiving. We will share the rules and the procedures. So, we are in a very advanced stage of a negotiation with them. It's a very interesting concept. We will be sharing pretty soon. So I will not take much time. So please.
Thank you and good afternoon. I am an academic researcher, not a practicing lawyer. Why Singapore has taken lead? There are several reasons. One reason, of course, Singapore comes out as an independent country, and many of the cases that are going to Singapore from India, they will go, because often they need independent space for negotiation, for arbitration. But we can get into other kind of cases, like with the Europeans are litigating with, have disputes with China or other countries, Middle East, they can come to us, but they're not coming to us. Now, for any country where domestic arbitration has not picked up, it's impossible to go for international arbitration as a hub. Now, how it is not possible? Like if you look at our courts, our population has grown since independence. Our GDP has grown significantly over the last couple of decades. Yet our number of courts and judges remain almost limited. Now, if your number of judges are limited, your number of retired judges will also be limited. So with just 1,500 arbitrators, you can't think of, with Indian size and economy, you can't think of arbitration picking up and international cases would come to you. It's simply impossible. When you have limited number of arbitrators, number one, they will tend to charge higher fees, the cost will be higher. You will also have, because the limited number of arbitrators are arbitrating so many cases, so you will have delay in the arbitration itself. So there is no way we can think of not having expert arbitration in India if you want arbitration to pick up. Second thing is about judicial review. I understand that our constitution would not allow delinking, but we can think of limiting grounds of review. On what grounds we allow, what grounds we do not allow. Third thing is that the new amendment that we have been talking about, I think it has gone one step ahead, that for international arbitration, it has said that only High Court can adjudicate, not the civil court. My question is, why only international arbitration, international disputes? You can do that for domestic disputes also. I think that would be a good step forward. Third thing is, of course, everybody has talked about, we need good institutional mechanism as well as infrastructure. It's not fair to go to IHC, IIC or hotels for arbitration. We need physical infrastructure. That's how it is done. So these are the short points I would like to make. Thank you.
I'm Rajiv Quatra from Punjab and Haryana High Court, Chandigarh. Much has already been said. The main point which I feel requires consideration is establishment of a nodal agency, as Lata ma'am has rightly said. And secondly, training of advocates. Like my friend has explained in case of Singapore, they have explained training of advocates. We require more and more advocates as number of arbitrators are very less if we analyze the number of disputes that is on the very higher side. Thank you so much.
Good afternoon. My name is Advocate Hariom Jindal. Many of the points have already been said, so I'll just point out 2-3 very, very small points. They are small, but they may be significant in terms of the number of small entrepreneurs that are doing business in India. See, many of the small business houses, they're afraid of arbitration, especially when they're dealing with big corporate houses. First of all, the place of arbitration fixed by the big corporate houses is a place which is convenient to them, which does not suit the small business houses in India. So they avoid going in for arbitration as per the choice of the corporates. Second is there's a lot of lack of trust in the arbitrator itself. The small entrepreneurs feel that the big corporate can easily influence the arbitrator. So therefore they feel that it is better to avoid the arbitration than to go in for arbitration. So I think I'll restrict myself to these 2 points.
Thank you very much.
Yeah, hello everybody. I'm Jayashree from Dheer & Dheer Associate. It's a law firm. Everybody here has been talking about problems, issues, arbitrations only after the problem comes. Nobody is thinking about why is it coming. So I generally feel on the part of the proverb that prevention is better than cure, I think when all of us sitting here who are lawyers would advise clients or advise when they do the contract, see that the contract has all the, then the arbitration or the litigation doesn't come into place. That's the first thing which I think all of us need to work. And I have a good example. I just want to share one example with you over here. A large FMCG company had hundreds of contracts with various vendors which were not even renewed for last 10 years. And believe me, they, we helped them. It was a lot. I think the contracts ran into some 300 or 400 contracts, and they literally saved 200 crores. It would have gone to litigation or for arbitration. And that is one which I want to, and most of the other points have been shared by all the people here. The second, of course, is the specialized people, specialized domain specialists, which are not here, which some of the people here and here said, that they have to have specialized people. Only then, if it's a pharmaceutical expert, only he will be able to give you the right kind of advice over there. That's it from my side. Thank you.
Thank you. Hi everyone, I'm Pranab Mago. I'm Head South Asia with SIAC. I have no new points to make as to what can be done. I think so everything has been covered. But I'll take this opportunity to address a few points which I just noted down. First and foremost, for any country to be an arbitration hub, obviously we have examples. We have examples of England and Wales. We have a perfect example of Singapore. I had been practicing there before coming to Mumbai. The most important thing is judicial support. Where is that? Firstly, I would like to question that. I think so. Most of us would agree that the judicial support has only started coming in now. The very mindset of judges needs to change. You shouldn't be looking at who the arbitrator was when an award comes in front of you. You should be looking at the award and whether it can be challenged. Secondly, amongst all the suggestions that we took, my friend from the Singapore High Commission suggested ecosystem. Ecosystem is a very, very broad term. Let me address a few things in that, and obviously points from others as well. To develop an ecosystem, as we said, not only the mindset of the judicial, not only we need the judicial support and the mindset of the judiciary needs to change, our own mindset as practitioners, our own mindset as GCs, that needs to change. We were all talking about expert arbitrators, the need for expert arbitrators. Yes, not all retired judges can be expert arbitrators, but at the same time, we have practitioners who are experts in their own field. Mr. Anand is here, an authority in IP. Is the mindset yet, and I know this, I have spoken to a few lawyers and from very big law firms, and I asked this question, it was in fact yesterday only I asked this question, are you reluctant in appointing an arbitrator who's partner of a big law firm? The answer came yes. So what about that? What about change in that mindset that needs to come in as well? GCs, yeah, we all know, we've all heard loads and loads of stories about nightmarish experiences in ad hoc arbitration. We still go in for it. When you have institutions, on that note, institutions, everyone I think so here has agreed that there's a need for a nodal agency. India is, one of the questions is time ripe for India to have its own arbitration nodal agency? I think so, not just time is ripe, time has passed long gone. So we are late, and very late at that. But at the same time, till the time the agency is not there, LCIA was here, SIAC is there with the geographical proximity. SIAC doesn't have an office in India, let me just qualify that. But these institutions exist. They are willing to do business in India. What is stopping the current crop to be moving to those institutions which exist? Another thing that was brought about was partnership with Singapore. My friend sitting across said that. Yeah, take the partnership to Singapore. I would suggest take it to a next level. Till the time you don't have a nodal agency, recognize SIAC in the statute. I'm sure our ministers, if they are listening, they can work something out. So the need has to come from within. Saloni asked me a question, how it works with SIAC. The model is very simple. The model is public. To replicate it, it doesn't need a genius at all. Again, it's already there. Everything is public. Just literally need to pick it up. And if it has to be that simple, it can be copy and paste. SIAC, another thing I wanted to just raise, recently it was, I think so, day before yesterday or on Sunday, it was announced that Mumbai is going to have its international arbitration. Just very quick point. It's going to have its international arbitration. Delhi already has one. What are we waiting for next? Bangalore, Chennai, and Calcutta also to have one.
Yeah.
So I would just rest at that.
सभी लोगों को नमस्कार। यानी कविराज जी, लता मैम साहब और रामास्वामी जी, सभी यहाँ भाई बहन आए, सभी लोगों को सुना है। मैं तो आपके सेशन को देख रहा हूँ। कोर्स कॉर्पोरल होना चाहिए और जैसे लोहा स्पेशलाइजेशन कोर्स होना चाहिए। दूसरा मेरा सुझाव है कि एक्सपर्ट टीचर्स हों जो सब्जेक्ट को बेहतर हैंडल कर सकें। आर्बिट्रेशन एजेंसी नॉमिनल फीस चार्ज हो, इससे भी लोगों पर बड़ा असर पड़ता है। फीस वगैरह हम लोग जिस तरह है, सेपरेट कोर्स हों ताकि तुरंत कार्रवाई हो सके। आज व्यक्ति अदालत में खड़ा है, जज हों चाहे लॉयर्स हों, सम्मान घटा है, विश्वास घटा है। गवर्नमेंट ऑफिस हैं जितने भी, वहाँ फाइलों के चट्टे लगे हैं, उनके जितने भी केस नहीं कंप्लीट हो पाते हैं, उनको उलझाया भी जाता है, उलझे रहते हैं। यदि हम इसको टाइम पीरियड यदि इसमें फिक्स करेंगे तो निश्चित रूप से वो किसी जितने भी हैं वह सुलटेंगे। और आज जो जनता का विश्वास कम हुआ है, वह काम विश्वास पुनः बढ़ेगा, ऐसा मेरा विश्वास है। मेरा नाम इंद्रजीत तार, मेयर आगरा। परिचय देने में मैंने पीछे से परिचय दिया है, मेयर आगरा का। सब लोगों को नमस्कार।
Hello everyone. Thanks to Mr. Ramaswamy for giving me this opportunity. I am Avdesh Goyal. I am not from legal fraternity. I am a chartered accountant, cost accountant and company secretary. At present, I am running a business of real estate and having 12 projects in North India. Much has already been said. I am just sharing my personal experience. In my opinion, a consolidated fees must be fixed in the judge when we are fixing the arbitrator, so that intentional delays will be reduced to some extent. Focus will also be once the award will be passed, how to get it executed, because after that lot of things will arise and you are not able to get the things done and the whole purpose of arbitration is delayed. And yes, I am concerned with point number 8. In my opinion, there must be an expert arbitrator in the initial one, and in the last 2 sittings we can use retired judge so that the time and cost will be reduced, and a joint order can be passed so that we can take the benefit of expert arbitrator who will make the brief and properly tell to judge, and in the last 2 sittings we can use the benefit of both.
Good afternoon all. I am Advocate Supriya. Good afternoon all. I am Advocate Supriya from Arna Law New Delhi office, founded by Shreyas Jayasima, Bangalore. Firstly, I would like to thank INBA for giving me this opportunity to speak. Already all thoughts have been shared today, but I would still discuss point 8 and 10. Do we need to shift our focus to expert arbitrations from retired judges? As Pranav said, I recently met Justice Singhvi at one of the conferences on competition law, and he discussed with me that yes, we do need experts, because he said not even in arbitrations, but even in courts, we need lawyers who are expertise and who are well versed with the LLMs in those subjects. He said that will help us because judges from Supreme Court retire at the age of 65. They are not experts in that particular subject. So this is one point. Second, our 2015 amendments is a way forward, way in the right direction. I would say that section 29A, which sets a rule of 12 months time period and 6 months extension, I don't think arbitrations can finish in that time period, but if they can finish, then after 18 months, it may get terminated itself. So does anyone have an answer that after termination, what will happen?
Thanks. Yeah. Mr. Ajay Thomas, can I ask him to come over here? So you don't have a mic at the back, so you can come over and there is a seat. Ajay, please. Yes, sir. Your voice will not be properly recorded. We want evidence.
Having been part of LCIA, we don't want to miss the opportunity of hearing you.
Well, to briefly introduce myself, my name is Ajay Thomas, and it would suffice to say that I'm an arbitration enthusiast at this point in time. And it is in that capacity that I speak here today. I believe the fundamental problem with arbitration in India, which none of us have talked about, is a lack of discipline in the process. Be it with due respect to amongst the arbitrators and also with the lawyers. So I think what you need to analyze and see is how do you fix this lack of discipline in the arbitration process amongst the arbitrators and amongst the arbitration lawyers. For that, I think we need to go back to the court system. Who are the people who are servicing? Who are the lawyers and who are the arbitrators servicing arbitration in India today? It is a broad genre of lawyers called dispute resolution lawyers. And dispute resolution lawyers effectively are lawyers who go to court and who also act as counsel in arbitrations. So if we need to fix arbitration in India, my 2 cents suggestion is that you need to fix the discipline in the mainstream public justice system in India today. If you were to analyze and look at jurisdictions which have been successful in the field of arbitrations and which have come to be known as hubs for arbitration, be it London, be it Singapore, Hong Kong, or even for that matter, Malaysia, KL, they've got a very efficient litigation system. They've got a very efficient way in which the general litigation is conducted. And the discipline from that general litigation process also flows into the whole arbitration system. And in my view, that's how you can fundamentally actually really change arbitration in India. And that's something that we need to focus on. That's all I have to say, but I need to make one point regarding this whole issue of being a nodal agency. I think what we need to realize in India is that we already have a plethora of arbitral institutions already in place. If you see Singapore, I was a part of the Singapore International Arbitration Center, so I must admit that. In Singapore, you only have the SIAC, so it was very easy to designate the SIAC as a nodal body, as the authority, the appointing authority for arbitrations and ad hoc arbitrations. Similarly, if you go to China, Hong Kong, you have the HKIAC. So it's very easy in these jurisdictions to have one institution to be designated as a nodal authority. But with due respect, I think it'll be extremely difficult to have a nodal institution in India, given that we already have an existing plethora of institutions. We don't need more institutions in India. I think what we need is to actually, for our existing institutions, to pull up their socks and be more efficient. After all, we've had the Indian Council of Arbitration in India since 1965. The SIAC was established in 1991.
But they don't have a case.
No, they do. The problem is that what you need to be doing is you need to be selling that process. And that's where Singapore is a shining example how they've beautifully sold arbitration, the process of arbitration. And so you need to have the ability to talk the walk and walk the talk. Thank you.
Anti.
I would...
Anti is still left.
Yeah, Mr.
Anti, please. Please come here. Take the seat.
Hello, everyone. I'm Kanti Mohan Rostagi, presently a practicing lawyer. Earlier, I was an in-house counsel. I think most of the suggestions have been made, and we have been compared to Singapore. Based on my past experience, one thing that I would like to say is that, India is not just Delhi and Mumbai. There are courts in MP, there are courts in Uttarakhand and across the country where the judiciary is not aware of the provisions of the Arbitration Act. And therefore, even when there is an arbitration agreement, the judiciary will continue with the civil court trial. So I think the first thing that if we want to promote the arbitration, we need to create that awareness across the country within the judiciary, at the district court level, so that when there is an arbitration agreement and a civil suit is filed, the judiciary does not continue with the process. The second thing is that while on one hand we are all talking of arbitration, what is very, very important, and in my past experience, we always found this in the companies that I served for, that Indians as such are not aware of the mediation process and how it can help in dispute resolution. That kind of awareness is also to be created within the corporates for the in-house counsels. That's the second point that I want to lay emphasis upon. The third point, what our overseas counsels always thought was that in India, arbitration is always a part-time dispute resolution process. And that's what we need to get rid of. And we need to, by way of expert arbitrators, by way of counsels who practice only in arbitrations, can really address upon that. And this will be a difficult exercise, but I think it needs to be done if we need to focus on this. And lastly, very importantly, is that arbitration is not something that can be imposed upon the organizations. So I think the fears that some of the small industry people, and when you deal with the government organizations where they impose their arbitrators, those fears need to be addressed. That can only bring about a culture of alternate dispute resolution process, and I will not limit the alternate dispute resolution process to arbitration. It involves mediation also. Thank you.
Yep, thanks.
I would request Mr. Parveen Anand.
I think as almost the last speaker, I feel like the last husband of Sophia Loren. I know my job, but I don't know whether I can make it interesting. Let me say this. I'll take some of the points which everybody has said and just maybe add a little flavor to them, and maybe take not more than 3 minutes maybe. First, on training of mediators and arbitrators, I'll tell you what our experience has been. When we started intellectual property disputes, we went in a big way to mediation. And the first almost 5-7 cases were failures. They all failed. And the reason was that the mediators were not using the right technique. They were using mediation as settlement. Mediation is not settlement. The mediator has to have his own agenda. He has to take private caucuses and arm twist parties. He has to scare them. He has to follow a certain technique. Once that technique was learnt by some mediators, they were highly successful, and the mediation success rates went up by about 70% in the Delhi High Court alone. That's one. So technique has to be taught. Second, best practices all over the world. There are so many good practices which each one can learn from other countries and jurisdictions, and to get people to come here and lecture on what best practices to have. A group of judges and lawyers went for training into San Diego and California area, and we learned techniques. One of the techniques we learned was early neutral evaluation. We came back, and I'd argued a case before Justice Kaul on early neutral evaluation, and we got the first case, and it was used so effectively, and it was all a direct result of training. And so training is really, really important. Second, I would link it to having a database of experts specialized in special fields. Today you have such sophisticated fields, and you get granular, they can go really deep. For example, in energy, you can have wind energy, and you can have, in wind energy, you can have blade specialization, and so on. And you really need experts, because judges will take a lot of time, as we've recently learned from our Roche case in the Delhi High Court, Roche versus Cipla. The single judge had some difficulty in understanding what a polymorph was, and you really need a chemical. The moment we went to the division bench, The judges had science background. They understood what a polymorph was. It took very little time to explain the point to them. So training and having this specialist judges in the field. Third, awareness. I think the public, in the beginning particularly, clients opposed arbitration mediation because they didn't understand the benefits. The moment you've kind of trained them to understand that you can save a lot of cost and confidentiality can be preserved and whatever other benefits there are, that awareness needs to be created. Third, most important, I think, is a place. We have a real struggle when we have people coming from overseas as witnesses. There's no place, there's no room in the High Court. And so you need a physical location. You need technology, very important. We were 2 weeks doing a trial in London, and they had a program, computer program called Opus Magnum. It was a database program which managed 40,000 pages of documents. There were 2 screens before every lawyer and before the judges. The moment you would say exhibit so-and-so, one of the screens would put up the document and the other screen would have the cross-examination in real time. And so you were able to do 300, 400 pages, 350 pages of cross-examination in a day on shorthand machines. Whereas you don't have that infrastructure of shorthand machines or of document management, so that speed becomes an issue. Plus, it was day-to-day, which meant that in 2 weeks, 16 witnesses, in 10 working days, 16 witnesses and the arguments were over. That kind of thing is only conceivable if you have technology. Then we in the Delhi High Court, for the first time, I'd used PowerPoint. Now it's used quite regularly. But video conferencing, the first case was the Mattel case. But there the Delhi High Court said, you must have somebody from the Indian High Commission present at the other end to make sure that the witness doesn't get assisted. It took 6 months for the Indian High Commission in London to clear that. The next time was the Shering Plough case, when in video conferencing, we got a notary public to sit at the other end, which was much quicker. The third case was the DuPont case, where Justice Endlaw said, you don't need a notary public, you don't need a high commissioner, you just need technology, a full wide-angle camera to make sure that there's nobody else in the room. And so it became so easy that in 2 days you could implement the order. So we reformed like that, but there were no rules. So the rules had to be created on a case-by-case basis. So technology, place, awareness, training, experts, and a database. Finally, timelines, fixed timelines, and you can learn a lot from the UDRP. Uniform Domain Name Dispute Resolution is online arbitration, where within 3 months, you have an award, email filing, email responses, and everything is done by email, and you get an email award at a cost of less than $2,000 US. And it's UDRP law. It's not American law, it's not Indian law, it's the best practices from various countries. So there's a lot to be learned on fixed timelines. And finally, having a financial system of financial incentives and disincentives like costs. Very, very important to have costs. The damages culture has come up in the Delhi High Court from 2005 onwards. Now there are about 220 cases on damages. Today, damages are acting as a serious disincentive. So that needs to be, that culture really needs to come to arbitration and other dispute resolution. That's all. Yes, of course.
Yeah, now I have a question to the Mr. Krishnan Malhotra. Do you think he is practicing in a taxation law? So what's the role of arbitrator can be in tax disputes? What's the position, legal position as of now?
In terms of the tax, if you would look at the position, maybe we have been using quite effectively mutual agreement procedures. So we don't see so much of arbitration, and neither it is recognized in income tax, but certainly under the double taxation treaties which we signed with different countries, under the mutual agreement procedure, the two one from the assessee side and one from Indian side, especially from the Ministry of Finance, they sit together and they can agree to disagree also. So mutual agreement is one. Alternative, especially now in the transfer pricing, we have started, again, it is just like an advanced ruling, where you get some ruling upfront so that there is a level of a certainty. But as such, arbitration is not the one which has really been arrived at, or neither we see any provisions in income tax.
Would you suggest that we should have arbitration in tax disputes?
You see,
mediation?
Unless we will not be able to have a strong arbitration, as you very rightly put in, that we don't have a very strong infrastructure in arbitration, people need to go to London or to the Singapore. Unless we will not create arbitration awareness and have a good structure for arbitration for the legal laws where you can resolve the things out of the court, I don't think, because here the dispute in income tax is not between the two parties. It is with the government, which is the tax department. So therefore, the arbitration would not be something which we can think as far as the income tax is concerned or the taxes are concerned. So I think first we should focus more on the legal aspect to create an infrastructure and awareness, as very rightly explained. And I really appreciate that. And that is where I think the awareness is required.
Thank you very much, Krishna Malhotra. Now I request Mr. No.
Yeah, can I just respond
Yeah,
on the
you
tax
have
aspect?
a question. Just give us a 5.
On the tax point, on the arbitrability of tax disputes. There are two kinds of tax disputes which happen. One, which was just mentioned. The other is bilateral investment treaty related arbitration on tax disputes. What's happening with Vodafone, Shell, etc. Bilateral investment treaty, there the government is separately negotiating it, and they're pushing back on arbitrability of tax related disputes. On the base erosion profit sharing mechanism, which has been recently, OECD has new set of guidelines, which a lot of countries are to adopt. There, Government of India has pushed back on arbitrability of tax disputes. The government does not see taxes as a matter which is arbitrable. The same way, historically, we have not seen issues like fraud, oppression, mismanagement, etc. as being arbitrable. As far as taxes are concerned, between two countries, it's a matter of sovereign power.
Absolutely.
So as a policy, it is being taken as not arbitrable. As a matter of law, you just need to amend constitution or something.
Thank you. Now, may I request Mr. Virendra Sharma, Honorable Member of Parliament from UK. He is also Chair of a Parliamentary Committee of Indo-British Partnership.
Thank you very much, Kaviraj, and thank you very much for asking me to come and listen to all these distinguished legal experts sitting here. Listening to most of you, and also listening to Kapil in the beginning, rather than saying Kapil Chaudhary, we still have used to age factor is there, so you don't go into those formalities. Kapil has given this indication that model role, Singapore. I personally believe, though I'm not going to talk about what is happening in India and how you're going to resolve the issue, which is up to the legal professions here and the government of the land to decide. But only problem being from Indian origin, those settled in Britain now, I feel that taking up the role models from overseas for India is always a difficult one. Because the mindset, which if we, the whole debate so far is the individuals and the system's mindset. Which way we wanted to go, are we accepting it? Are we ready for it? If we are not ready, can we make people to move towards that direction? Because laws are there, but implementation is always if you change the mindset. So if you have a law in Delhi, maybe Punjab is not going to accept it, then they have their own ways. Unless you have the universal national rules which every state has to follow, rather than individual states have the laws and the center has to ignore it. That is where the problem is. Britain, as couple, I was sharing with a couple that how does he feel that when I see the most efficient, transparent system in Britain, which is word people generally accepts it, that most fair system, but he told me that it's very expensive too. When you compare, when you were talking about the cost, others were talking about the cost, that how is it going to, the client going to suffer, or who is going to bear that cost is important. And then who is going to say, no, enough is enough? Do you have vested interest in delaying the tactics? Because you have to say that the arbitrators and those people who are going to decide it, what interest they have in the matter. Do they get, and no disrespect to anybody here sitting in profession type, everybody run their business, though there's a in the profession there's the ethics, but when the money comes, sometimes people just bypass the ethics and say, no, this is important, there's an opportunity to make money. So I think that this is where the both sides, where you are talking about the problems, then how you're going to change the mindset that if not my generation, not Kaviraj's generation, at least one other generation to change that and move towards it. There is a delegation, I think, working on in the month of June, coming to Britain, and I'm sure that there will be opportunities during that meetings and talking to the lawyers and as well as the judges to see what can be brought here. But one thing I must say before I just stop it, that the relationship between Britain and India, because those are the historical relationships for many, many, I mean, we generally say 400 years, because it was 400 years ago, 1614-15, when Roy Thomas went and presented his credentials to Emperor Jahangir to say that I'm representing the Queen of Britain. So that's where the relationship started. And that's where we would be certainly happy that the relationship be strengthening, not only individual basis, in the professions as well. We're learning from each other. Because Indian diaspora, for different problems, legal problems, though they are living in Canada, America, and Britain, have the disputes here. Though it's a small amount, not the multi-billion pounds disputes, even 100,000, 200,000 pounds, 300,000 pounds worth disputes, but the delays in the court processes where it costs you more than what is the original price of the dispute was. So they have that interest, that if there is a reform in the system here, that they don't have to wait and the laws and the judgments are not delayed, or the awards are not delayed through the legal system, and getting some independent outside the legal system, out of the court, how you can bring those justices to those people. So there's a diaspora interest as well. So we would like to see more improvements, and certainly wherever there's a working relationship, we can work. I'm not a lawyer, so that's why I'm not going to make any suggestions to the Indian system, But I will certainly say that if Indian system need to learn from Britain, because you will be in a better position to judge it, which country's role model is better than for us to adopt, or just to have the foundation and follow it up from there. If you think the British model is good for India, come to Britain, study the system there, come on a delegation, which will be organized. It's not, I'm not selling it. Don't think that
he has invited us.
Being the chair of the our party parliamentary group, I wanted that not only there was somebody here who is a singer, that only the cultural links are developed. I wanted the professional links also developed so that the future generations also continue supporting each other. So I would love you to consider that, and if there's any way I can help the system to be reformed here, I will be grateful on that and feel obliged and privileged to assist in that matter. Thank you very much, Kaviraj, for asking me to come here. I'm not a speaker here today, so I'm not going to go and carry on speaking, but certainly I thought.
Like to add, like I think majority of contracts, we have actually English law as a jurisdiction. So we are actually following the laws of England, and that is more preferable, though they are quite expensive. So definitely when we have clients, because like most of our clients, 40% of the revenue is coming from Europe, so it's always the English law jurisdiction, for most of the companies.
Ma'am Lata would like to say a few words.
Yeah, thank you very much, because I have the benefit of listening to the extremely stimulating and learned discussions that went on. I want to take just 2 minutes more to just tell you what I have in mind. One is that I want to take up the Honourable Member of Parliament from England on what he just offered, that he should really try and work towards having some sort of a collaboration with the English, arbitration institutions, the London institution, as well as people like Anand should participate in trying to train lawyers. We're talking about training arbitrators all the time, but the lawyers also need to be trained, because most of them are also completely innocent of technicalities, and we do need experts who present the case before the